and welcome to the Secure Your Creation podcast starring Mario Milano. I got to make sure I say that properly. Milano from Milano IP. Hey, Mario, explain to everybody who you are and what you do.
Thanks, Craig. Yeah, I'm Mario Milano, owner of Milano IP. We help clients protect their inventions with patents, trademarks, copyrights, and trade secrets. We help them identify what would be the best form of intellectual property to protect their ideas, and then we help them go ahead and obtain that protection.
Awesome, awesome. So today's topic that we're going to talk about here is patent wars and litigation. That's the focus of our podcast today. And I know when we were doing our pre-recording brief, Mario, we were talking about patent portfolios. So just for the clarity, to make sure we're all on the same page, tell me what a patent portfolio is.
Sure. So a patent portfolio is a collection of patents that are owned by a company or a common entity. The patent portfolio, I would say, contains any issued patents that they have and any pending applications that they might have. Sometimes people will include expired patents to make it pump up the numbers a little bit, but generally the expired patents aren't something that we're concerned with. So it's usually just pending applications and issued patents. It can also be broken down into what each portfolio, a company, they might have an entire patent portfolio. And then they could also have a portfolio directed to product A, which would be their patents that are only covering product A, and then a portfolio for product B as well.
Awesome. So in terms of, we're going to talk a little bit more specifically today about medical device companies. So a question I guess I have for you is, how does startup and mid-sized medical device companies protect themselves against patent lawsuits from larger competitors who are trying to block their entry into the market? What strategies can they use to defend themselves?
Yeah, that's a big problem for smaller companies. When a large company, you don't want a large company asserting their patents against you. And so the number one way to avoid that is to do a patent search before you release your products commercially. And typically I tell clients, look, once you have your idea, you know what you want the product to do, you have a general idea of how it's going to function and the components of the device. Well, let's do a patent search, a couple months before you get to final engineering stages, before you get to production. Let's do a patent search. We'll identify your competitors' patents and their pending applications. And we can make sure that the design that you have in mind, or the couple of designs that you have in mind, are not going to infringe the rights of others. Once you do the patent search, then you'll know what's out there and you can then design your product accordingly.
And so I know when we talked before as well, we talked about basically how the big boys, if you will, that's what we'll coin them in this conversation. The big boys have a money bank, right? Talk a little bit about that and how that affects maybe a small to medium size or even a medical device company who's just in the entry or starting this process.
Yeah, when the big device companies have to file a patent lawsuit, it's very expensive. The bigger companies are able to finance those types of lawsuits, and it's part of the course for them. But for a smaller device company, defending against a patent infringement lawsuit can be very expensive. And so the bigger companies will recognize that, and sometimes will just assert their patents, knowing that the smaller company may not be able to afford an ongoing lawsuit litigation. And so the smaller company will then have to decide, either stop selling their products and not enter their market, or to sell their patents, or to otherwise somehow just relinquish their patents or abandon their commercial activities.
Awesome. Okay. So let's talk about planning that comes with these patents. So if you're in a situation, tell me about what Milano IP might do for a small to medium-sized medical device company who comes in and maybe has a 2-year plan, a 5-year plan, a 20-year plan, a 50-year plan. I don't know. You tell me.
Yeah.
What type of things would you guys do for somebody who has that plan, who's entering the market against the larger competitors?
Yeah, and that's a conversation that we like to have with any new client or existing client. We constantly talk about, okay, what's the plan here? And so, they come to me and they say, we're going to be releasing a new product. Okay, what's the plan for the product? Is this something that we think is just going to sell for 2 or 3 years? Is this something that's going to be sold for 10 or 20 years? Is this new product going to be the platform that the whole company is built around? And you're going to specialize in this one product. For example, you might be a small medical device company and you're going to make spinal implants. Well, those spinal implants, that might be what the company is known for. Some of these smaller companies, if you only have this one team of engineers, they might all be working on spinal implants. And so we might come up with the base product and then expand from there. If that's the case, then we want to get very robust patent protection and get a really robust patent application that we can then build off of later. And so we ask the company not only what is the product for, then we start to talk to the company about, okay, what is the founder's plan? Are they going to be in this business forever? Are they just trying to, get some commercial success, build up a patent portfolio, and then sell to a larger company? If that's the case, then we take steps to make sure that it's attractive to outside investors or larger companies. And the thing you have to do there is make sure that you have a really good product and make sure that you have very robust patent protection. Keep your patent applications open, meaning that once you have a patent that's issuing, you file a continuation application so that you can then get additional patents directed to those products. And the big companies certainly like to see that. When you have open patent families like that, as we call it, now the big guy can come in, he can buy your patents from you, and then they can also use those patents to then get additional patents for themselves.
Wow. So give me a rough idea. I know this is a spur of the moment thing, but what can having so many patents do for the value of your business when you go to sell?
Yeah, that's certainly going to increase your value a lot. Sometimes the bigger competitors will look at the smaller guys and they'll say, okay, they have a decent product, but there's room for improvement there. And of course, the larger companies all think that they can improve on products that are out there. And not only is the product have some room for improvement, but the intellectual property is where some real value is. Maybe the big company A knows that big company B is infringing the patents of the smaller company, but the small company might not have the funds to go ahead and assert their patents. So sometimes large company will say, I'll just buy that patent portfolio, I'll buy the company, and then I can assert those patents against other people, or just use those patents for myself to come out with a superior product.
Wow. So in framing this next question, think about it from the context of the larger corporation. And when we spoke before about the terms of the patents and being able to make sure that it's, a 2 to 5 to 20 or whatever year space, what would you suggest for a smaller company who's just looking to get started and compete? What would you suggest their process or their steps should be beyond the I'm losing it here. What would their process be beyond the search? Sorry.
Yeah. So their process, would start with the search. And when we do the search, we can identify the entire patent portfolio of the large companies. And we look at, the entire patent portfolio, and we make sure that we understand how are we going to defend against a lawsuit if, the large company goes ahead and asserts their patents against us. Because you don't want to have, you have your product. You don't want to say, oh, well, this is how our product operates. And while you're backing away from the claims of one patent, you might be backing into the claims of another patent that within that portfolio. And so we take a holistic approach by looking at the entire patent portfolio of a competitor and making sure that any of the arguments that we're making, that we can say how our product is made, what the components of it are, and how those components function, and its shape and form, and make sure that we have a clear argument on how we are not infringing any of the patents. Instead of just looking at each patent one by one, we look at the entire patent portfolio to make sure that we have some room to operate.
Very good, very good. So you're always looking out for the person who you're working for. I love to hear it. So tell me about briefly some of the other stuff that you're looking for from an IP perspective for maybe a medical device company. Whether you're talking about trademarks, whether you're talking about trade secrets. Tell me a little bit more about that side of your business when it comes to medical device companies.
Yeah, so trademarks are certainly going to be something that you're going to want to get established early. Again, just like with patents, you want to do a search there. Make sure that you're going to be able to get a trademark for your company or for your new product. You come up with a new product name, new product tagline, all those things you're going to want to protect all those things. And so, we can go ahead and do a search, make sure that you're clear, and then file for it and make sure that you get the trademark that you need. And so the trademark, it helps if you need a great product, and you also need to be able to market it. And so that's where the trademark certainly comes into play. Now, sometimes from a device standpoint, sometimes you might come up with something new that's hard to detect exactly what you're doing, but it might not be patentable. So in that case, we talk to the client, we say, okay, if somebody else was to just buy this product off the shelves, would they be able to tell what you're doing to achieve the superior results of your product? And if the answer is no, then sometimes it's not worth it to file a patent application. Then we just keep that under our hat, if you will, and keep that as a trade secret.
So in terms of your service with your client base, there's obviously a consultation side of that, right? Because most people come in, I would assume they come in, they know how their product works, and they have all these different options to it, and they're very strong in terms of how that thing should work. What type of consultation side of things, when it comes to patents and trademarks and so forth, do you offer your clients?
Yeah, so we offer an initial free initial consultation where we talk about the product, how did you come up with it, who do you know that it's a competitor that's out there. Let's make sure that we are at least clear of the competitors that you know of. And then not only do we talk about what the product is, and this is one of the key components that some inventors or smaller companies might not recognize, is we don't want a patent just on what you're doing. We want, if you had 5 different ways to do this or to make this product, we want to put all 5 different ways into the patent application. That way, if your competitors come along and try to adopt a similar concept to what you were doing, maybe your competitors say, okay, they came out with this great product, let's just design it this way. Well, that was an idea that you already have. And now you already have that in your patent application. You can prevent your competitors not only from doing what you're doing, but from doing anything even close to what you're doing.
That's awesome. That's awesome. So as we round out the show here, what I want everybody to know, if you enjoyed the Secure Your Creation podcast, don't miss a single episode. Hit the subscribe button on your favorite podcast platform to stay informed on the latest IP strategies, legal insights, and expert advice. And if you're finding value in the content, leave a review. It helps us as creative businesses to discover the show, for others to discover the show, I should say. Before I take off here, Mario, do you have any last parting things in terms of these patent wars and litigation that people should be thinking about?
It's always better to find out what your risks are before you get a letter of accusing you of infringement. So do the search early, and anytime you come up with improvements for your products, make sure you go ahead and do another search for that.
Awesome. Awesome. I'm Craig Andrews. This is Mario Milano, and stay tuned for our next episode of Secure Your Creation podcast, and we'll talk to you next time. Have a great day.